Good evening, everyone. Welcome again to another live streaming of tax training. And I would like to say thank you po sa ating mga subscribers. Umabot na po tayo ng 24,100. No? Thank you very much. And much as naghahanap po kami ng updates dun sa case ni Senator Manny Pacquiao, but wala po kami makita, no? Na nasa Supreme Court or nasa Court of Tax Appeal. So, yung record po ng case ni Senator Manny Pacquiao, yun lang po yung diniscuss natin na last, no? Yung 2016, no? So, hindi tayo nakapag-research dahil wala tayo nga makita sa Supreme Court at sa Court of Tax Appeal. So, right now, ganun lang yung discuss natin po sa case ni Senator Manny Pacquiao. And shout out, Harry.
Wala pa pong,
Ha?
wala pa pong shout out. Pero may viewers naman 9.
Okay, so shout out po sa mga viewers natin. And good evening po. No? Our discussion today, kasi wala tayong tax update, wala tayong mga regulations, no, na bago. So we will discuss about a case, no. Ito yung na pili natin, yung Commissioner of Internal Revenue versus the Court of Tax Appeal, no. This is about excise tax versus the Bureau of Customs and the Collector of Customs, and then Philippine Shell Corporation versus Philippine Shell Petroleum Corporation versus Court of Tax Appeal, First Division, Commissioner of Internal Revenue, Bureau of Customs and Collector of Customs sa Batangas, no? Sila yung mga respondent. And ano tong case na to? These three consolidated cases originated from Court of Tax Appeal, case number 8535, wherein respondent Philippine Shell Petroleum Corporation assailed the validity of document number M59-2012 and the consequent demand letter, October 2012. This is about the assessment, no? By the collector of the Port of Batangas, collector of the Bureau of Customs, requiring Philippine Shell to pay 1,994,677.47 in deficiency excise taxes, no? Ang laki. Inclusive of interest and penalties for its alkylate importations between January 2010 to June 2012. 1.9 billion, ha? Ito yung facts kung bakit nagkaroon ng ganyang kaso, no? Philippine Shell is a corporation engaged in the manufacture and distribution of petroleum products, no? As an integral part of its manufacturing process and to comply with Republic Act number 8749, known as the Philippine Clean Air Act of 1999, and the Philippine National Standards, no, PSPC, started to import alkylate, a raw material and blending component to be mixed with other substances to produce petroleum products. For PSPC alkylate importations between May 2010 until August 2011, no, the Bureau of Internal Revenue, BIR, issued a 21 authorities to release imported goods at TRIG. Ito yung nagbabayad na sila in advance, no, para ma-release yung kanilang importation, which all stated that alkylate was not subject to excise tax, considering that it is not among those articles enumerated under Title 6 of NIRC 1997. So, ang ginawa ng BIR, nag-issue siya ng atrig pero walang babayaran kasi yung alkylate daw hindi subject to excise tax. Subsequently, the BOC further conducted an independent third-party test of the specification of alkylate. So, ang BOC or Bureau of Customs, nag-conduct siya ng test, no? sa alkylate, which showed that alkylate was in fact not in the nature of premium plus, premium or regular gasoline, but a mere component additive, and hence should not be subject to excise tax. Additive lang siya, so hindi raw dapat i-subject sa excise tax. Yan ang sabi ng BOC or the Bureau of Customs. Despite these findings, records show that the BIR in September 2011 began inserting alkylate in the atrig it issued for PSPC's alkylate importation, stating that the BIR tax assessment was without prejudice to the collection of the corresponding excise taxes, penalties, and interest, depending on the final resolution of the Office of the Commissioner on the issue on whether this item is subject to the excise tax under the NIRC of 1997. So, pero doon sa atrig na binigay ng BIR, may note siya doon na depende pa sa result ng study ng Office of the Commissioner kung subject pa o hindi sa excise tax ang alkylate. Since the atrig were issued directly to the BOC and not to PSPC, the latter only found out about the kulatilya later in the proceedings. Yung kulatilya, yun yung may notation doon. No? Further, around the same time, September 2011, the collector also sent a request for a legal opinion to the Department of Energy or DOE. Yun ang pinaka dapat na ginawa, no? Kasi yung may authority at saka regulatory is the DOE, sila yung may say talaga kung subject ba o hindi ang alkylate. With respect to the nature of alkylate, in letter dated June 27, 2012, the DOE likewise held that alkylate was not a finished product but an intermediate product, hence not subject to excise tax. In spite of all the foregoing findings, the collector still issued a memorandum dated June 4, 2012, addressed to then Commissioner of Customs, Rosano Rufeno Biazon, Commissioner Biazon, requesting for a formal legal opinion on whether it could collect excise taxes on PSPC's alkylate importations. Commissioner Biazon forwarded the same to the BR through a letter dated June 13, 2012. In the meantime, PSPC discovered the kulatilya in its atrigs. Consequently, it filed a letter to the BIR Large Taxpayer Services decrying violation of due process. No? The BIR LTS, however, did not reply to this letter as of the time of filing of the instant case. No? So, on June 29, 2012, the CAR issued document number AM059-2012 in response to Commissioner Biazon's June 13, 2012 letter. No? So, yung Commissioner. In this issuance, the CIR cited the report of the BIR Laboratory Section Excise Taxpayers Regulatory Division, which found that alkylate was similar to naphtha as a product of distillation. Based on this, it opined that alkylate importation are subject to excise tax. Okay. So, para sa akin kung ako lang personal, ginagamit mo yan na raw material sa bakit walang excise tax? No? So, ginagamit sa gasoline. And corresponding value-added taxes, but afterwards, Commissioner Biazon issued Customs Memorandum Circular or CMC number 164-2012 on July 18, 2012, directing the collector to take appropriate action based on document number M059-2012. Itong M059-2012, ito yung nagsabi na yung alkylate importation are subject to excise tax because, anong sabi niya? Similar, alkylate was similar to naphtha as a product of distillation. No? So, aggrieved PSPC filed a petition for review with the Court of Tax Appeal on August 24, 2012. So, syempre, pag aggrieved ka, saan ka pupunta? Syempre, sa korte. And since it involved tax matters, so, saan siya pupunta? Sa Court of Tax Appeal, no? So, on August 24, 2012, a selling document number M059-2012, it claimed that the said issuance was actually an invalid BIR ruling since it was issued without factual basis and in violation of its right to due process. So, yun ang sabi niya, walang due process. Pero yung kanyang mga atrig, may nakalagay na doon na subject to the result ng commissioner. No? PSPC's petition was docketed as Court of Tax Appeal Case number 8535 and initially referred to the CTA 2nd Division. In August 2012, the BIR began issuing a trig assessing PSPC's alkylate importation for excise tax. So, since meron ng ganong resolution or ganong pronouncement, no, na yung alkylate is similar to naphtha as a product of distillation. So, yung subsequent na atrig, yung authority to release imported goods, meron ng assessment sa excise tax at saka VAT, no? Kasi importation. Okay. Agri-PSPC filed petition for review with the CTA on August 24, 2012, no? Assailing document number M059-2012. It claimed that the said issuance was actually an invalid BIR ruling since it was issued without factual basis and in violation of its right to due process. PSPC's petition was docketed as CTA case number 8535 and initially referred to the CTA 2nd Division. In August 2012, the BIR began issuing a trig assessing PSPC's alkylate importation for excise tax. As such, PSPC filed verified urgent motion for the issuance of a suspension order with a prayer for immediate issuance of a temporary restraining order dated September 17, 2012. Kung mapapansin ninyo sa basic natin, no, sa principle in taxation, bawal mag-issue ng restraining order or injunction sa collection ng taxes. Pero in this case, na file ng restraining order ang Shell, no? So, verified urgent motion in CTA case number 8535 seeking to enjoin the collector and the BIR, no, from implementing document number M059-2012 for PSPC's subject and future alkylate importation. The BOC and the collector opposed the same. No? So, on August 31, 2012, Commissioner Biason sent a letter to the CIR requesting for assistance in the computation of deficiency excise taxes and applicable interest. Talagang yung customs at saka yung BIR, nagkaisa talaga sila na i-impose yung tax na yon sa i-collect yung tax sa Shell, no? On September 5, 2012, and the CIR issued letter reply containing the requested computation and the aggregate amount of 1.9 billion. As a result, on October 1, 2012, the collector sent a demand letter to PSPC for the deficiency excise taxes, inclusive of interest and penalties, in the amount of 1.9 billion, as computed by the CIR in her September 5, 2012 letter reply. Because of this development, PSPC amended its petition for review in CTA number 8535 to include the October 1, 2012 demand letter. Okay. On October 5, 2012, the CTA 2nd Division initially denied PSPC's September 17, 2012 urgent verified motion on the ground that no assessment has yet been issued. Wala pa namang assessment na na-issue. No? However, on PSPC's motion for reconsideration upon presenting the October 1, 2012 demand letter, the CTA reversed itself via a resolution dated October 22, 2012 and issued a suspension order covering the 1.9 billion demand by the collector. No? This notwithstanding, the CTA clarified that it was granting a suspension order only on the amounts covered by the assessment contained in the demand letter, which was for importation from January 2010 to June 2012, and not a general suspension order as to future or incoming shipments. And in this future incoming shipments, it held that it had no authority to enjoin the collection of taxes sans an actual assessment. Notably, the October 22, 2012 resolution did not rule on the PSPC separate prayer. Verified urgent motion for the issuance of TRO to enjoin the implementation of document number M059-2012. Thereafter, the CIRBOC and the collector filed an omnibus motion to dismiss the case, to lift the October 22, 2012 suspension order, and to require PSPC to explain how it obtained document number M059-2012. Kasi internal paano siyang nakakuha noon? Andin yun pa yung final niya sa Court of Tax Appeal. Essentially, they argued that the CTA has no jurisdiction over the case since document number M059-2012 was neither a ruling nor an adverse decision, but a mere internal communication between the COC and the CIR. No? So PSPC failed to exhaust the protest procedure under the Tariff and Customs Code of the Philippines in order to properly contest the tax assessment in the October 1, 2012 demand letter, thus rendering the same final and executory. So, tinetechnical naman ng BAR at BOC yung shell, no? And PSPC failed to prove its entitlement to a suspension order, no? The omnibus motion was opposed by PSPC, which maintained that document number M059-2012 was in fact a BAR ruling and was issued by the CIR in the exercise of her quasi-judicial power. In any event, it would fall under the other matters jurisdiction of the CTA. No? So, yun naman ang contention ng Philippine Shell, no? Jurisdiction daw talaga ng CTA. Okay. So, November 19, 2012, the CIR filed a separate answer in CTA case number 8535. Similarly arguing that the CTA did not have jurisdiction over the case and that PSPC failed to exhaust administrative remedies. So, yung PSPC daw failed to exhaust administrative remedies, dumiretso na lang sa Court of Tax Appeal. Prior to the resolution of the omnibus motion, PSPC filed two separate urgent verified motion for suspension order for its alkylate importation on November 5, 2012 on December 17, 2012. In a resolution dated January 4, 2013, the CTA denied the December 17, 2012 motion on the ground that no assessment has yet been issued by the collector for the alleged shipment. Meanwhile, in a resolution dated January 28, 2013, the CTA Second Division denied the November 5, 2012 urgent verified motion and the omnibus motion. So with respect to the urgent verified motion, the CTA reiterated its position in its January 4, 2013 resolution that no suspension order could be issued sans an actual assessment. As to the omnibus motion, it held that it has jurisdiction over PSPC petition since the assailed document number M059-2012 was actually in the nature of a BI ruling, and the likewise assailed October 1, 2012 demand letter was a tax assessment, given that liability of the taxpayer was definitively determined. Finally, the CTA held that there was sufficient basis to maintain the suspension order over the 1.9 billion assessment in October 1, 2012 demand letter. May shout out? Oh, sige.
Shoutout po sa mga viewers kay Ma'am Jonaline Bonlang, good evening daw po. Kay Liana Viloria.
Okay.
Kay Maria Teresa Valle. Kay Ma'am Lilian Yao, good evening daw po.
Okay.
Shoutout din po kay June Sarmiento, kay Estela Bestor, kay Ma'am Rosalina Tune from Cebu City.
Okay.
Kay Sir Jojo Trimor.
Okay po.
Kay Ma'am Jessica, good evening daw po. Kay Ma'am Malu Sintos, and then kay Ma'am Miss Cupcake Confessions, kay Sir Eugene Cruz,
Okay.
and then kay Ma'am Rodora Constantino. Good evening daw po sa lahat.
Okay.
Sila pala po.
O sige. Wala pang question?
Wala pa po.
O sige. Ito po para sa mga bago lang natin na viewers. our discussion today revolved around the case, no, as decided by the Supreme Court on the case of the Philippine Shell, no, Corporation on their importation of the raw materials na noong 2012 na ginagamit nila sa kanilang paggawa ng premium gasoline, no? So nag-import sila ng raw materials pero hindi nila pinapa-subject sa excise tax. Kaya nung nagkaroon ng laboratory test, yung BAR at saka customs, kung subject ba sa excise tax o hindi, yung raw materials na ginagamit ng Philippine Shell doon sa paggawa niya ng kanyang gasoline, no? The findings states that it is subject to excise tax, no? So since subject siya sa excise tax, dapat magbayad sila ng excise tax. That's why inassess sila ng 1.9 billion, no? So nagprotest ngayon itong Philippine Shell. Okay. So the CTA held that there was sufficient basis to maintain the suspension order over the 1.9 billion assessment in October 1, 2012 demand. So anong sabi ng court, no? Dapat daw isuspend yung assessment na 1.9 billion. Unperturbed, the BOC and the collector moved for reconsideration but was denied by the CTA First Division, not the Second Division, due to a reorganization. In a resolution dated June 24, 2013, the BOC and the collector then elevated this resolution to the CTA in bank through a petition for review docketed at CTA case number 1047. However, in a resolution dated February 10, 2014, the CTA in bank denied due course to their petition for being the wrong remedy to contest an interlocutory order of the CTA First Division. Undeterred, the BOC and the collector filed their petition for review on certiorari before this court, no, Supreme Court, assailing the CTA in bank resolution, which was docketed as GR number 211294. Okay. So on June 17, 2013, PSPC filed yet another urgent verified motion for suspension order for its alkylate importation. This time presenting the import entry, an internal revenue declaration, and the ATRIG corresponding to its importation to prove an existing assessment against it. This was opposed by the BOC and the collector. Excuse me. On the other hand, the CIR filed a motion to dismiss in response, reiterating the grounds she raised in her separate answer, no, filed CTA case number 8535. In a resolution dated July 15, 2013, the CTA First Division denied the CIR's motion to dismiss on the ground that the CTA's jurisdiction over the case had already been settled through the CTA's resolution dated January 28, 2013 and June 24, 2013. Furthermore, it granted PSP's June 17, 2013 urgent verified motion and issued a suspension order covering the excise taxes for PSPC's alkylate shipment under IEIRD number C1298-13 and C1301-13. The CIR's motion for recommendation was denied through a resolution dated January 14, 2013, prompting it to file a petition for certiorari before the court, assailing this twin resolution, which was docketed as GR number 210501. Thereafter, PSPC filed several other urgent verified motions for suspension order for its surrendering for its succeeding alkylate importation from September 11, 2013 until February 26, 2014. No? So, ang dami na niyang importation. But the same were withdrawn due to the CTA's inability to resolve the same within the 15-day period under the TCCP. On March 19, 2014, PSPC filed its urgent verified motion for the issuance of a suspended order against the collection of excise taxes and value-added tax thereon on the shipment of 80,162 barrels of alkylate as delivered by the vessel MT Marine Express. However, this was denied by the CTA First Division in a resolution dated April 2, 2014, opining that it has no jurisdiction to issue suspension orders on incoming alkylate importation because the same were not covered by the amended petition for review. It held that the PSPC failed to initiate protest proceeding and that in any event, jeopardy was not proven. Distressed by the CTA's sudden change of position, PSPC filed a petition for certiorari with an application for the issuance of a TRO and/or WPIB for this court, assailing the April 2, 2014 resolution of the CTA, which was docketed as GR number 212490. Okay. Okay. So, na tuloy pa rin yung kaso, no? May question, ha?
Wala po.
Okay. Just, So, what happened to this case, no? Proceeding before this court. In a resolution dated July 7, 2014, this court consolidated all three petitions and assigned the case to a member of the Second Division. It likewise granted PSPC's prayer for injunctive relief and issued a TRO enjoining the Customs and Taxing Authority from imposing excise taxes on the incoming alkylate importation. No? So, panalo sila sa Court of Tax Appeal. Okay. Importation of PSPC under document number M059-2012 upon the posting of an appropriate ban in the amount of 496,944,000. No? Kasi pag nagpa-TRO ka, i-post mo ngayon, ilagay mo sa band yung tax liability mo. No? Kasi pag natalo ka, ang band mo ang sasagot. No? So, in July 30, 2014, and upon posting of the required band, the court confirmed the issuance of a TRO based on the July 7, 2014 resolution. In the meantime, the BOC and the collector filed their motion for reconsideration to the issuance of the TRO, which was denied in a resolution dated October 22, 2014. So, denied yung kanilang resolution, no? Motion for reconsideration. Okay. So, after some time, the BOC and the collector filed a motion for issuance of a status quo ante-order, no? Seeking the suspension of CTA case number 8535 in light of the court's July 15, 2015 decision. Okay. Okay, so case number 8544 involved challenge of the validity of CMC number 164-2012, which is related issuance to document number M059-2012 in Petron. The court held that any challenge to an administrative issuance must be brought to the regular courts and not the CTA. And that the taxpayer petition was premature for failing to observe the protest procedures under the TCCP. Based on this, The BOC and the collector argued that the CTA should have suspended its own proceedings in CTA case number 8535 pending the final resolution of the motion for reconsideration in Petron. So in a manifestation and comment, PSPC posited that there was substantial distinction between the instant case and the Petron case. Okay. So on October 25, 2020, the Office of the Solicitor General filed a motion to lift the July 7, 2014 TRO on the ground that the injunction has already caused inseparable injury to the government. No? So, ayan ang sabi ng Solicitor General. Sobra-sobra daw yung injury na nagawa niya sa gobyerno, no? On the ground na binigyan niya ng injunction ang collection of taxes. Kasi regularly, hindi talaga pwede ang TRO or injunction on the payment of taxes. Okay. So, the issues before the court. Based on the pleadings, the issues may be summarized as follows. Okay, so number 1, are the CIR, BOC, and the collector guilty of forum shopping? Okay. So, guilty of forum shopping daw yung Commissioner of Internal Revenue at saka Bureau of Customs. And then, does the CTA have jurisdiction over the subject matter of CTA case number 8535 in conjunction to this issue? Document number M059-2012 SBA ruling. Does the CTA have jurisdiction over the challenge against the validity of the document number M059-2012? Was there a violation of the doctrine of non-exhaustion of administrative remedies as to divest the CTA of its jurisdiction? No? The CTA have jurisdiction over the challenge against the October 1, 2012 demand letter. Okay. So, yun yung mga issues, no? Does the CTA have jurisdiction to issue suspension order over the assessment against PSPC? No? Okay. Does CTA in bank have jurisdiction over the BOC and the collector's petition for review, assailing the CTA divisions denied of their omnibus motion to dismiss? Okay. So, ito na yung mga court's ruling. Okay. So, the CIR, BOC, and the collector are guilty of forum shopping. So, guilty daw yung BAR at saka yung Bureau of Customs ng forum shopping. Okay. Forum shopping exists when party repetitively assails of several judicial remedies in different courts, no? So, nagsampa ng iba't ibang kaso sa korte, simultaneously or successively. All substantially founded on the same transaction and the same essential facts and circumstances, and all raising substantially the same issues either pending in or already resolved adversely by some other court. In order to prove forum shopping, the following must be shown. Identity of parties or at least such parties as represent the same interest in both actions. Identity of rights asserted and relief prayed for. The relief being founded on the same facts and the identity of two preceding particulars such that any judgment rendered in the other action will, regardless of whether party is successful, amounts to res judicata in the action under consideration. So, guilty daw ng forum shopping yung Commissioner of Internal Revenue and the BOC. Okay. So, mahaba-haba. Ito, wala pang question? Ilan na yung viewers natin?
50.
Okay. Sige. So, kasi mababa pa to. Nasa first issue pa lang tayo on the uh, uh, guilty ba ng forum shopping yung CAR or BOC, no? Bakit guilty ng forum shopping? Kasi tapos na yung case. Nagdidemanda pa rin, no? Excuse me. Okay. So likewise, there is an identity of parties in this case. The rule is that absolute identity of parties is not required, but only a shared identity of interest. Here, although the BAR and the Bureau of Customs are separate government agencies, in this particular instance, their function overlap with respect to the assessment and collection of excise taxes for imported articles. So undoubtedly, excise taxes are in the nature of internal revenue taxes, no? Kasi ang excise, di ba, classified siya as national taxes. No? So excise tax talaga is national internal revenue tax, no? Under the NIRC yan, tax code. Okay. However, by the express mandate of Section 12A of the tax code, the COC and his subordinates, including the collector, are agents of the commissioner with respect to the collection of national internal revenue taxes on imported goods, no? Okay. So subject matter of CTA case number 8535 solely relates to the imposition of excise taxes on PSPC's alkylate importations. Thus, any attempt, no, on the part of the collector of the BOC to collect the same must necessarily proceed from their deputization or as agent of the BAR. This agency relation was in fact confirmed by the collector during his testimony in one of the suspension hearing to it. Do you confirm, Mr. Witness, that the authority of the collector to collect excise tax proceeds from that trig issued by the BAR? The answer is yes, sir. And it is actually the BAR that makes the computation in determining in its ATRIG the excise tax liability for articles which is deemed excisable. Yes, sir. No, puro yes, sir siya. In finance between GR number 210501 and 211294, there is forum shopping. No? Nevertheless, the court recognized that the issue of the CTA's jurisdiction is perfectly to the issue raised in GR number 21490. No? So whether or not suspension orders over the assessment against PSPC's authorized and future alkylate importation should be issued by the CTA. Hence, jurisdiction questions may be considered by the court at any time if such is necessary to the disposition of the case. No? The court shall rule on the same. So yun yung ruling niya doon sa second issue. No? The CTA's jurisdiction over the subject matter of the CTA case. Okay. Okay. Wala pa rin? Wala pa rin question? Sige. May viewers pa. Okay. So, tuloy lang po tayo ha. Anyway, ang ano natin ngayon is question and answer, no? Pero, since wala din namang mga updates, why gusto din sana namin na i-discuss sa inyo pa yung further the case of Senator Manny Pacquiao kasi nga ang daming nanonood ngayon. But, we cannot discuss na wala tayong pinanghahawakan, no? Why? Kasi wala akong makita ng decision ng Supreme Court o yung decision na pa ng nag-appeal sila o whatever, no? So, hindi natin siyang pwedeng i-discuss. Yun lang yung available natin, yung matagal na, no? Okay. So, what sets apart BAR ruling from other issuances of the BAR is that it relates to a particular taxpayer set of facts and circumstances and a consequent determination of taxability or tax exemption. So, when applicable to this regard, it is readily apparent that the tenor and working of document number M 059-2012 qualify it as a BAR ruling. No? Okay. Excuse me. Ito yung letter ni Philippine Shell. Dear Commissioner Biason, we refer to your letter dated 13-2012 forwarding the memorandum dated June 4, 2012 of District Collector Rene M. Benavides of Collection District Number 4, Batangas, seeking our opinion ruling on the propriety of the demand for payment of the unpaid excise tax and the corresponding value-added tax against Philippines Shell Petroleum Corporation amounting to 1.3 billion on its various importations of alkylate from the year 2010 up to the present as declared in 28 import entries. So, yung 28 import entries na yan, puro exempt yan. Kaya lumaki yung computation because kumbaga saan nag-accumulate na yung kanila importation. So, ruling. The subject importations are subject to excise tax and the corresponding VAT on the said excise tax. Hence, we find no legal impediment on the issuance of the deemed letter against PSPC for the collection of the excise tax and VAT amounting to 1.3 billion, no? On its various importation of alkylate. Okay. As contained in the January 18, 2012 report of the OIC Chief BR Laboratory Section Excise Taxpayers Regulatory Division in terms of boiling rains, volatility, and recovery process. No, alkylate qualifies as a product similar to naphtha used as gasoline blending component. Naphtha is produced by fractional distillation of crude oil or by other refinery processes and recovered from refinery streams by fractional distillation. No? So similarly, alkylate produced by other refinery process, which is alkylation, is recovered also by fractional distillation. No? Alkylate is a very important blending component of today's reformulated motor gasoline because of its relatively low vapor pressure, high octane number, and near zero content of sulfur, aromatic, and olefins. No? So in relation thereto, Section 148C of the National Internal Revenue Code in IRC of 1997 as amended imposes an excise tax of 4 pesos and 35 cents. No? That is for every liter of volume capacity of naphtha, regular gasoline, and other similar products of distillation. No? So, to wit. Clearly, alkylate, which is a product of distillation similar to that of naphtha, is subject to excise tax under Section 148C of the NIRC of 1997 as amended. Wala pa rin shoutout.
Shoutout lang.
Sige.
Ma'am Josie Tindo Bambao from Zamboanga del Sur.
Wow! Good evening po sa mga taga Zamboanga del Sur. No? Iwan ko lang kung maulan sa inyo, pero dito talaga sa amin maulan. Sa malakas ang hangin, sobra. Okay.
Siya pa lang.
Sige. So, sabi ni Commissioner Hinares, please be guided accordingly. No? Kasi sabi niya, in view of all the foregoing, this office is of the opinion that the importation of the subject article, no, by PEC are covered by excise tax at the rate of 4.35 per liter, no? So under section 148 of the NIRC of 1997 as amended. So PSPC should pay the amount of 1.3 billion expressing the unpaid excise taxes and the corresponding VAT. No? So may VAT na yan. Exclusive of increments on the importation of alkylate from 2010 up to the present as declared in the 28 import entries. Sinong may nag-sign pa dito? Si Commissioner Jacinto Hinares. Okay, so what happened na dun sa ibang mga issues nila? Okay. So, next issue tayo, no? The CTA has jurisdiction over challenges to BIR issuances such as document number M059-2012. It is relevant to note that during the pendency of the proceedings, the issue anent the certiorari jurisdiction of the CTA over direct challenges to the validity of tax issuance was not yet definitively settled. No? So according the parties cited conflicting jurisprudence is there numerous pleadings before the CTA and the court. No? However, on August 16, 2016, the court in bank promulgated Banco de Oro versus Republic of the Philippines, wherein it was definitively settled that the CTA's jurisdiction over challenges to the validity of tax issuances. Notably, this overturned the previous doctrine in British American Tobacco. No? So, what happened to this case? No? What happened to this case? Wala pa rin question? Ari? Ha? So, what happened to this question? No? Kasi, ano na tayo? What happened to this case pala? Ito na yung decision ng court, ha? Sa Shell. Okay. Sige.
Ma'am Marieta Ato.
Okay.
May I ask the consequences of a warrant of distraint issued by the BIR? And what are the next moves that a taxpayer should do?
Yung warrant of distraint po kasi, kukunin na sa inyo yung mga personal property nyo no? So, ang next niyan, kung makuha na yung personal property nyo, dinadala nila yan sa BIR and then in auction sale, no? To answer for your tax liabilities. Ngayon, kung sobra o malaki yung na-warrant of distraint nila, sobra doon sa liability sa BIR, ang ginagawa ng BIR, binabalik yung sobra sa may-ari. But in the event also na kulang, mag-garnish pa sila or maglilib pa sila ulit. No? So, ganun po ang ginagawa. Meron pa?
Meron pa.
Okay.
Galing kay Ma'am Eunice Condes.
Okay.
Question daw ma'am about sa 2550M filing.
Okay.
Opo, I am new po sa isang company and napansin ko na mali po ang pag-compute po nila ng input tax allocable to exempt sales.
Okay.
Yun lang ma'am.
Ipo-prorate kasi yung input tax allocable to exempt sale. So, since bago ka sa isang company, and then previously mali yung ginagawa nila, you try to make an adjustment, no? Itama mo na. Lalong-lalo na ang input tax allocable to exempt sales, favorite talaga yan na hanapin ng examiner during the tax audit. No? Hanapin talaga niya yan. Papaano ka sana yung allocation mo ng input tax ng exempt sale at saka nung batable sales. No? So, anong gagawin mo? You have to adjust. No? And then inform. Kasi pag nag-adjust ka dyan, it might be na may mga kulang kayo na bayaran, no? So, gawin mo siguro yung tamang computation and then present it to the management. Anyway, hindi naman ikaw yung magde-decide dyan. No? Ang sayo lang, gagawin mo lang na ipakita mo yung tama na computation.
Sabi niya po ma'am, formula po nila is total exempt sales divided by total sales times total purchases imbis na total input tax. As I check po, since 2018 pa na ganito sila mag-compute.
So, ang gagawin mo siguro, kung masipag ka, then from 2018, igawan mo siya ng computation na tama na, and then pakita mo ano yung difference, no? Para kung halimbawa, pwede kayo amend since 2018, kung wala pa kayong letter of authority, pwede nyo pang i-amend, no? To reflect the tama. Okay?
Ma'am, tanong po ni Maria Atok tungkol po kanina sa warrant of district. What if it is issued to corporation daw po?
At kung issued siya sa corporation, naka-direct yan sa board of directors, no, at saka sa mga officers. So, ano pa rin po siya, valid pa rin siya, unbinding, no? So, ganun pa rin ang gagawin ng BAR. Kung yung levy nila ng mga property, binibenta po yan at public auction, at kung kasya na yan doon sa liability, then tama na, kukunin na nila. Pero kung kulang, magagarnish pa sila ulit or magwa-warrant o district and levy pa rin sila ulit. No? Kasi kulang pa yung binayaran. Pero kung wala nang property, pinagpakasya nila yan, no? And then, dormant na lang yung account. Okay.
Tapos ma'am, follow-up po question ni Ma'am Eunice Condes regarding dun sa 2550M. Ano po daw kaya magandang gawin dun ma'am? I-amend ko po ba? Ano po magiging consequences?
The best mong gagawin, gawa ka muna ng matrix. No? Ano yung effect nung since 2018, gawan mo ng monthly, ano yung effect? Pagka very material yung effect, you have to amend. Pag sinabi kong material, malaki yung amount na involved. Just like mga, kasi VAT ito no? And then you're talking about input tax. So pagka mga siguro 100,000 or whatever na very material na yung amount, kailangan mo na talagang mag-amend. Pero kung halimbawa ang effect naman dun, 200 pesos, 300, 500 pesos, or 1,000, might as well, wag na, no? Current mo na lang, i-go current mo na lang. Yung ayusin mo na lang yung sa iyo, kung maliit lang naman yung effect niya. Pero kung malaki, balikan mo talaga yan, no? Balikan mo talaga yung 2018, mag-amend ka. Ilang years yun? Mahigit 2 years, no? 2 years and a half. 2 years and a half ang i-amend mo. So, 12, 12, 24. Tsaka 6. Bali, 30. 30 na returns. Okay. Gawan mo muna siya ng matrix na computation sa Excel. Tapos tingnan mo kung how much is the effect per return. Pero kung mga minimal lang, hindi na kailangan. No? Okay, next. Okay. So, yan po yung nagiging desisyon ng court. No? And then, anong sabi niya? Although there was a violation of the non-exhaustion of administrative remedies, the exceptions are applicable in this case. No? So, itong case, favorable talaga to sa Pilipinas Shell. No? Under the doctrine of exhaustion of administrative remedies, recourse through court action cannot prosper until after all such administrative remedies have first been exhausted. If remedy is available within the administrative machinery, this should be resorted to before resort can be made to courts. It is settled that non-observance of the doctrine of exhaustion of administrative remedies result in lack of cause of action. Ganun yung nangyayari. Which is one of the grounds in the rules of court justifying the dismissal of the complaint. As case law illumines, the rule on exhaustion of administrative remedies emanates from the policy of allowing administrative agencies to tackle matters with the specialized areas of their respective competence, which in turn is based on committee and convenience. Okay. Okay, next. The Court of Tax Appeal has jurisdiction over the October 1, 2012 demand letter, no? So sabi niya dito, based on the facts on record, it should be noted that PSPC's original petition filed before the CTA was later amended to include October 1, 2012 demand letter sent by collector for the payment of deficiency excise taxes in the amount of 1.9 billion. So for January 2010 to June 2012, based on PSPC's allegations, which is as mentioned, no, administrative of subject matter jurisdiction, there is concurrent challenge to the validity of the tax issuance coupled with specific appeal over the tax assessments proceeding therefrom. No? So contrary to the CTA's opinion, its jurisdiction is not based on its jurisdiction, no? Over matters arising under the National Internal Revenue or other laws. Okay. Next, CTA did not have jurisdiction to issue suspension orders over the assessment against PSPE, alkylate importations, no, beyond the period covered by its amended petition for review. So ano niyang sabi dito? Wala siyang jurisdiction to issue suspension order kasi doon pa lang sa general principles natin, bawal talaga na ang collection ng taxes, ETRO mo, no? Yung restraining order. So, due to the confusion, the matter of the court takes this opportunity to clarify the CTA's power to issue general injunctive relief vis-a-vis its power to issue suspension orders under the CTA law with ancillary provisional remedies. PSPC both avail in this case. Okay. Okay, so tingnan natin anong ginawa sa kanila ng court. Ang lakas na naman ng ulan. Okay. Okay, CTA and bank correctly denied due course to the BOC and the collector's petition for review assailing the CTA division denial of the omnibus motion to dismiss. No? The motion for the issuance of status quo ante order and the motion to lift the temporary restraining order filed by public petitioners have been rendered moot and academic. Bakit siya moot and academic? Kasi hindi na siya kailangan, no? Given the court's final disposition herein, the motion for the issuance of a status quo ante order and the motion to lift the temporary restraining order have already been rendered moot and academic. The said motions are ancillary interim relief which were rendered functus officio by the ruling on the main as case law states. When injunction is sought as mere ancillary remedy, it cannot exist even except only as part of an incident of an independent action or proceeding, and exists only until it is dissolved or until the termination of the action without the court issuing a final injunction. So anong ginawa ng korte? The petition in GR number 210501 and 211294 are denied. No? So denied yung petition nila. Sino petition dito? The Commissioner of Internal Revenue. Talo ang Commissioner of Internal Revenue dito. No? While the petition in GR number 212490 is partly granted, in that the case is hereby remanded to the Court of Tax Appeal, First Division, to resolve the issue of the propriety of issuing a temporary restraining order. Questionin talaga sila, no? Kasi hindi nire-restrain ang collection of taxes. And or writ of preliminary injunction to enjoin the implementation of document number M059-2012 during the pendency of CTA case number 8535 in accordance with this decision. In view of the foregoing final disposition, the temporary restraining order dated July 7, 2014 issued by this court is hereby dissolved. Winala na niya yung restraining order. And the motion for issuance of a status quo ante order filed by public petitioner is denied on the ground of mootness. No? So, sino pa ang mga pumirman dito? Si Stella M. Perlas Bernabe, Alexander Gismondo, Ami Lazaro Javier, Ricardo Rosario, Mario Lopez. Okay. So, attest the conclusion above decision, Stella M. Perlas Bernabe, Senior Associate Justice, and also signed, no, by Diosdado M. Peralta, Chief Justice. No, siya pa yung Chief Justice sa Supreme Court. Okay. The decision was promulgated in March 15, 2021. No? Okay. Wala na question? Okay. Since wala na rin po tayong question at saka ano na naman, may lockdown na naman, no? Yung mga offices, sarado na naman. And then we will resume on August 20, no? So, with that, I would like to say thank you po sa lahat ng mga viewers natin at saka sa mga nag-subscribe po sa atin. Thank you very much. And let's call it a night.